Good morning, everyone. We are just going to give it a second, let a few more people in the from the waiting room trickle in, and we are looking forward to having a great discussion with everyone this morning about the Trump executive orders. All right. With that, I will get things started. Hello, and welcome to today's webinar on the Trump executive orders. I'm Eric Searing, the Director of External Relations here at the Wisconsin Institute for Law and Liberty, also known as WIL. And today I'm joined by WIL Deputy Counsel Lucas Feber, Luke Berg, and our Managing Vice President and Deputy Counsel Dan Lennington. A quick word about the Wisconsin Institute for Law and Liberty. We were founded in 2010 by our president, Rick Essenberg. We are a Milwaukee-based nonprofit law and policy center that is committed to defending constitutional principles. Through litigation, we fight for individual liberties, equality under the law, constitutional government, economic freedom, and education reform. Our policy team works to advance sound public policies and push back against harmful government overreach at the local, state, and federal levels. As I mentioned, today we will be discussing the Trump executive orders. And given the speed at which they are being signed, the legal and political implications of these executive orders cannot be overstated. But what did these changes mean in practice? How will they shape federal and state policy moving forward? Today, our panel of legal experts will discuss. Lucas will start things off by discussing what executive orders do and the regulatory implications. Luke Berg will be covering the latest orders surrounding parental rights in Title IX, and Dan will be discussing the orders as they relate to the issues of race, diversity, equity, and inclusion. We are recording today's discussion and we'll be taking questions at the end, so please use the Q&A function. With that, Lucas, I'll throw things over to you.
Hey, thanks, Eric. And good morning, everybody, from frigid Milwaukee, Wisconsin, where it's about 5 degrees outside. But we've got some good info for you today, so thank you for joining us. First, just want to begin. President Trump has issued more executive orders. If we can go to the next slide. President Trump has issued more executive orders in his first 10 days in office than any president in history, but he is nowhere close to issuing the most executive orders in history, which is in the thousands, and that was FDR, although FDR's term was considerably longer. President Trump's orders range on a variety of issues, from broader topics to more specific, from hot button issues like defense and DEI to less controversial issues like establishing a commission to celebrate America's 250th anniversary. You can go to the next one. So we'll just begin with a little bit of background on what exactly is an executive order. So executive orders have been used by every president from Washington through the current Trump administration, with the exception of William Henry Harrison, who obviously only served for 1 month in 1841. Most of the earliest executive orders were never seen by anyone except the federal official whose conduct was being directed. In the early 1900s, they began to be published, and today all executive orders get a sequential number assigned to them, and they're all published in the Federal Administrative Register. So those are all public records that are available for anyone to see. So an executive order is a policy statement from the president. It's an official document whereby the president is directing or managing federal officials on how to administer or manage federal policy. Typically, they relate to the workings or administration of government. They direct federal officials. They tell them how to carry out their duties. It's not a replacement for federal law. They can't conflict with the Constitution. They can't allow somebody to do something that federal law otherwise prohibits, for example. Executive orders are issued by the president solely. They can be repealed solely by the president. Executive orders also they can last for a short period of time, or they could last in perpetuity until they're repealed. It really depends on the individual order itself and how it was constructed. Some of the historical examples, probably the most famous executive order in American history was Abraham Lincoln's Emancipation Proclamation. I think that's one that every American knows or should know, certainly. And they've also been used. That's obviously universally recognized as a good executive order. There's also universally recognized as bad executive orders, like, for example, FDR's internment camp executive order during World War II, which was used to move tens of thousands of Americans into internment camps. Executive orders have been used to create various agencies, like FEMA, for example, was originally created by an executive order about 50 years ago. We can go to the next slide. So where does the executive power come from? The executive power I'm sorry, where the executive order power come from? It's really inherent in the powers of the president. So the president of the United States is vested by Article 2 of the Constitution with the complete executive power. Article 2, Sections 2 and 3 list off various particular powers of the president, which would include the power to take care that all laws shall be faithfully executed. So most scholars typically point to that as the grounds for kind of executive order authority within the Constitution. It's really part of the president's duty to ensure that the executive branch is executing the laws faithfully. Executive orders are, generally speaking, designed to help tell when there's an exercise of discretion by the federal government, to tell what the official policy of the exercise of that discretion would be to those agencies. So to let them know how they're going to do certain things and how the president wants them done. Executive orders often begin with a statement as to what the purported authority is to issue it. Typically, it says something like pursuant to the authority vested in the president by the Constitution, and some federal statute that relates to the subject matter that the order is going to have. Typically, there's something in there like that. It varies, of course, order to order. And then I just note that as a check on this power, it's not unlimited. Congress, of course, has the ability at any time to pass a law which would overturn an EO. Obviously, such an act would be subject to a veto and then a potential veto override. Courts are also, and as many of you now know, many of the president's executive orders are being challenged in court, but courts can declare an executive order unlawful, especially, where it conflicts with the Constitution or it conflicts with federal law, where it violates the separation of powers. An executive order may be unlawful. Now, with that background on what executive orders are generally, I just want to briefly touch on some of the administrative state executive orders, and then we're going to talk just a minute about DOGE before I turn it over to my colleagues, Luke and Dan. First, on the administrative state, the president has issued he's issued more, but two primarily relevant executive orders for today. The first was called Unleashing Prosperity Through Deregulation. This executive order seeks in fiscal year 2025 to limit the administrative state's ability to promulgate new rules. So any new regulation is now required to be coupled with the repeal of 10 or more old regulations. It's a deregulatory order. Obviously, the practical implications of that are it's hard to define what is a regulation, right? I mean, they're not regulations themselves aren't written as like, here's regulation 1, here's 2, here's 3, here's 4. They're kind of written like statutes. So it can be a little bit in the details there. But what really, the real impact that this order will have has to do with the net costs. So the order requires that the net cost of any new regulation must be significantly less than zero. And that's achieved by repealing those other regulations. So what this means is that if an agency is going to impose a new regulation on the American people, that agency has to find other cost savings that would make the overall net cost significantly less than zero in order to promulgate it. So, whatever an agency is, whatever they want to put out there, if there's some regulation that they're going to put out this year, they need to find savings in order to offset any costs that they're going to impose on the American people. The order itself puts a little meat on the bones, a little more instruction. It requires the director of the Office of Management and Budget to work with agencies to implement it and to help define what those costs are and things like that. Another order that was issued immediately by President Trump is the regulatory freeze pending review. This is something that other administrations have done similar things like. It basically says no new rules can be promulgated until the new administration has a chance to get somebody, an appointee, into that agency to review those actions. Coupled with that, it required that any rules which were sent for publication but had not yet been published should be rescinded by the agency, should be pulled back for review. And also, it provides for a 60-day postponement on any rules that have been published but have not yet taken effect. So if there's rules of that nature, would have a 60-day postponement. Those are the primary administrative state reforms that have initially come out from the president. Very significant reforms, but again, something that is temporary in nature and would require congressional action to effectuate long term. I think the executive branch has a lot of power and to voluntarily exercise some of these regulatory reforms, but for lasting change, we would need an act of Congress that could bind the government going forward. Next, I just want to talk briefly about the Department of Government Efficiency, or DOGE, that has been in the news quite a bit. There were two primary orders that created and then refined the role of DOGE. The first was called Establishing and Implementing the President's Department of Government Efficiency. It renamed the United States Digital Service, has been renamed the United States DOGE Service. It created what's called the U.S. DOGE Service Temporary Organization, which will exist until the 4th of July next year, so about 18 months. It requires each agency to establish what it calls a DOGE team, which has to have at least 4 employees. It's a team lead, whoever's kind of in charge of the DOGE team, an engineer, somebody who can kind of look at the software stuff, an HR specialist, and an attorney. Obviously, the larger agencies are going to have more people on those teams, but each agency should have at a minimum 4 DOGE staffers as part of it. The DOGE temporary organization is required to essentially look at the government systems and see where we can achieve efficiencies. That's what they're doing. That's what you've seen in the news out there. They are looking at things like IT infrastructure and software, and just, where can the government be updated? How can we do more with less? Was what the executive order essentially requires them to do. It does require agencies to provide the United States DOGE service with what they call full and prompt access to all unclassified agency records, software systems, and IT systems, and requires those DOGE employees to adhere to what they call rigorous data protection standards in the executive order. So the next order, which came just, I believe, last week or the week before last, was further refining the Department of Government Efficiency. This was the hiring freeze, where the director of OMB is required to submit a plan which would reduce the federal government's workforce. It also included what's called a new ratio for new hires. So each federal agency can only hire 1 new career employee for every 4 employees who depart. It requires agencies to consult with their DOGE teams whenever they're going to make a new career appointment hire. And it also requires an immediate large-scale reduction in force. So agencies have to start looking at how they can start to reduce their federal workforces. It does exempt public safety, immigration enforcement, and law enforcement from that. But for the most part, federal agencies have to start under this order as part of the Department of Government Efficiency efforts are required to start looking at ways to reduce their workforces. So a lot of what we've seen from DOGE so far are recommendations on improving those efficiencies, software changes, things that the departments can do. And then, of course, related to staffing, a lot of that is in the news here. I would just note that I recently saw several states filed what they purported to be kind of a novel claim against DOGE, arguing that DOGE violates the appointments clause because they said these are officers of the United States who are not approved by the Senate. I don't think that claim works because these are temporary appointments, and to be an officer of the United States, you require an ongoing appointment by law, which they just don't have here. So I wouldn't expect that claim to go forward, but certainly there are a number of lawsuits that are out there that we're tracking and we'll have more information on to come. So with that, I will turn it over to my colleague Luke Berg for the next step.
Well, thanks all for joining and listening in. I'm one of our lead litigating attorneys here, and I'm going to be talking about 4 of the Trump administration's transgender-related executive orders. So I've been at Will for about 5.5 years, and I've done a lot of cases in this space, not because I care about this space in particular, but I think in this context, maybe more than any other, we've seen government power abused to silence of opposing viewpoints in a lot of different spaces and aspects of society. So just to give a few quick examples, in the 5 years I've been at Will, we've sued 3 school districts for hiding gender transitions from parents. We represent a counselor who was fired for speaking publicly in opposition to gender transitions of kids. We represented a teacher who was fired for a religious objection to using wrong sex pronouns. We represented 3 8th graders who were accused of sexual harassment for quote unquote mispronouncing by their school district. We're suing a city for banning counseling to help kids overcome gender dysphoria. So all that is to say, this ideology, that this idea that people can be born in the wrong body, that some men are really women and some women are really men, is showing up everywhere, as you all know. And we're just very happy that the Trump administration is making this a priority and combating this. But it's going to take some time, and it's going to be a long fight ahead. So I'm just going to give you kind of an overview of these 4 executive orders. I wish I could go into more detail than I'm going to be able to, but I'm just going to give you an overview, roughly what they do. So the first one the Trump administration issued was on day 1, and this one does 5 main things. So the first thing is language related. As you know, the federal government produces an enormous amount of material, websites, forms, resources, studies, etc. So the executive order begins by defining terms. It defines sex, man, woman, gender identity. Shocking that we need to define those terms these days, but that's the moment in history that we're in. So it defines terms. And then it says every agency has to go through all the materials that they produce and make sure that we are using sex and not talking about gender identity anywhere. And then any materials that it finds that promote gender ideology or use this gender identity concept have to be removed or edited. So that's going to be a massive undertaking. And the order gives agencies 120 days to begin doing this and to update the president on their progress. So the second main thing that the order does is it directs agencies, whenever they're interpreting statutes that use the word sex, to interpret sex to mean biological sex. What the Biden administration had done is to redefine the term sex to include and or cover gender identity. And so this is just going back to the text of what those original statutes meant. So the main 2 statutes that are relevant here would be Title IX, which is sex discrimination in education institutions, and Title VII, which is sex discrimination in employment. But there's lots of other statutes that reference sex as well. And just a quick comment here, it's perfectly normal for a president and an agency to take a position on what a word means in a statute. They have to apply the statute, and so they have to interpret the word whenever they're applying the statute. Obviously, if their interpretation exceeds the scope of the statutory language or disagrees with it, they can violate the statute, and courts can ultimately hold that their interpretation is inconsistent with the statute. But I think the Trump administration is pretty safe here. It was really the Biden administration that was attempting to rewrite federal law, and the Trump administration is just reverting to what the statute actually says. So the third thing in this executive order is that all government-issued IDs going forward will use sex and not gender identity. And then any government-managed facilities will remain sex separated to the extent that the administration can do that consistent with law. So the biggest category here would be federal prisons, but this also includes any restrooms or locker rooms in federal buildings. So where this applies and how this works out, every agency is going to have to figure it out agency by agency, but any federally managed buildings, sex separated spaces will be separated based on biological sex. And then lastly is sort of a very broad and generic direction to ensure that no federal funding is spent to promote gender ideology. Now, there's not a lot of detail as to how this will get applied. But remember, this is day 1 of the Trump administration, so it's a broad order. It gives us a window into where his administration is going. Every agency is going to have to work out what this means for their particular agency, and some of the future executive orders spell this out in a little more detail. But the broad position of the administration is we're not going to spend federal dollars to the extent we can. We're not going to spend federal dollars on this going forward. So that's the first executive order. The second one I'm going to talk about is actually the third one issued in time, but I think is the most important one, the one I care about the most, is attempting to end the teaching of gender ideology in K-12 education. And although I think this is the most important, the sort of challenge here is that I think the federal government has the least amount of power in this space. Typically, K-12 education is controlled by the local school district. And so the Trump administration is going to use the levers that it can to stop this as much as it can, but figuring out what those levers are, we will see. So of the four that I'm going to talk about, this order actually does the least directly in its own order, because what it primarily is a direction to create a plan as to what we can do. So the main thing this order does is tells the Secretary of Education, Defense, and Secretary of the Health Department to come up with a plan in 90 days to do the next three things I'm going to talk about in the order. And the first thing they're going to do is basically an audit. So go through the budget, as DOJ has been, line by line, and figure out every way that the federal government has been funding gender ideology in K-12 education. And the order directs the agencies to look in kind of two main buckets. The first is curriculum related. So any activities that we're doing with students, programs, curriculum, anything that the federal government is funding related to student activities. And then the second is teacher training. And then once that audit's been done and you've identified all this funding, each agency is to come up with a plan to eliminate and or restrict any of that funding to be used for teaching gender ideology in schools, socially transitioning children in schools, and lastly, any PPRA, FERPA, or Title IX violations. Put a pin in that for the moment. I'm going to talk about what those are. But the idea here is just after we figure out how the federal government is spending all this money, let's figure out if we can and how we can eliminate it. So a brief comment here. A lot of these executive orders are about eliminating the use of funding for things that the Trump administration disagrees with. A president has a lot of discretion in how to spend funds, but it's not unlimited. It really depends on the context of the congressional act and how specific it is. If it's a pretty broad grant of funds for a variety of topics, it's totally appropriate for a president to say, we're going to spend the money on this and not that. If it's a very specific congressional authorization, there can be less room for the president to stop funding things. So in every one of these executive orders, there's a key phrase that says consistent with law, and basically saying to the agencies, go through all of the funding, review the law, and figure out if there's a way consistent with law to stop funding this stuff. So we just have to wait and see what the plan ends up being. I'm sure parts of it will end up being challenged, but it's good that we're gonna eventually see how our federal government has been funding this and hopefully stop funding it as much as possible. And then the last part of this order is a direction to agencies to enforce these statutes, FERPA and PPRA in particular, which are existing federal statutes. And again, well within executive power for a president to say, I want you to prioritize enforcement of this particular statute when it hasn't been prioritized in the past. So what are these two statutes? So parental rights is largely a constitutional claim, but there's a couple federal statutes that are related to parental rights, and that's what the president's executive order is invoking here. So the first is FERPA. This is the Family Educational Rights and Privacy Act. At a high level related to parental rights, it gives parents access to their own children's education records in schools. And the second one is the PPRA, the Protection of Pupil Rights Amendment. This gives parents a right to notice and opt out of certain kinds of surveys and evaluations that are given to their children. So to know why he's invoking these two statutes, you have to know a little background about secret gender transitions in schools. So there are over 1,000 school districts across the country that have adopted policies to hide gender transitions from parents. So if a student wants to change their name and pronouns at school, start using the different bathrooms, a lot of school districts say, we will facilitate that. And if you don't want your parents to know about it, we will keep it a secret from them. And anytime you hear about these policies, the first question that people ask is, well, how in the world can they do that? and keep it a secret from parents. So a lot of these policies have what's called a gender support plan. This is a form where a staff member goes through a discussion with a student and says, okay, what are we going to call you at school? And often these forms include questions about the parents. Say, do they know what this identity that you're asserting, and do you want them to know? And if you don't want them to know, how are we going to refer to you when they show up at school? How are we going to communicate with them via email and the like? Now, this is a record produced about a child, a minor, so this would be covered by FERPA, but I don't know if you can read it. The very sort of bottom line, this is the Madison Metropolitan School District form, says, please keep this interview in your confidential file, not in student records. So this is a pretty, in my view, blatant violation of FERPA. It's an attempt to prevent the parents from getting access to this record. And the kinds of questions that are being asked, I think, are covered by the PPRA. And so it would actually require notice and an opportunity to opt out before this form is given to a child, but schools aren't doing that. So what the Trump administration is saying is, to the extent we find school districts that have a form like this that are using it, we are going to prioritize enforcement actions against those school districts. Now, this is not a silver bullet, because school districts can simply stop using the form, and some have done that. The Madison School District has eliminated its use of this form, but probably is continuing to socially transition kids without parents knowing about it. They're just not using the form. So it's not going to solve the problem entirely, but it is a tool in the administration's use that it can to shut down sort of secret social transitions of minors. The third executive order I'll talk about is intended to keep men out of women's sports, as it's titled. This does a few main things. The first thing it does is a direction to the Department of Justice to resolve the ongoing litigation over the new Title IX rule. So as many of you are probably aware, the Biden administration adopted a Title IX rule that went into effect in August that basically rewrites Title IX, says that sex equals gender identity. That rule has been challenged in 8 main cases, and in every one of those cases, it's been enjoined or put on pause. And just in January, one of the courts vacated the rule nationwide, which basically just means it's invalid. It has no legal effect unless and until that ruling gets appealed. And DOJ is the organization that's litigating it on behalf of the federal government. So this is a direction by the Trump administration, most likely not to appeal and to resolve that litigation. Now, that doesn't mean it's necessarily over. Somebody else could attempt to intervene and appeal on behalf of the Trump administration, but most likely this rule is not coming back. So that means the pre-existing Title IX regulations passed by the prior Trump administration are now back in effect, and the order says we're going to enforce those old rules. The second thing the order says is direct the agencies to bring Title IX enforcement actions against school districts that allow men in women's sports. And it's already initiated 2 against 2 different athletic associations. Now, there's nothing in Title IX explicitly that says schools cannot allow transgender students to play sports with the sex they identify with, but Title IX does require equal opportunities for men and women. So the argument and the theory here is, by forcing women to compete against men who have competitive advantages, you are actually not providing equal opportunities to men and women. And one federal court has already, at least in a motion to dismiss posture, accepted this argument, allowed a case to proceed. This is the Connecticut case over track. And the Trump administration is saying, we're going to proceed on this theory and try and bring Title IX enforcement actions against school districts. But obviously, it would be stronger if the rule said explicitly that women's sports have to be limited based on sex. So the third thing this order does is it directs the Department of Education to begin working on such a rule. So that's going to take time. It has to be drafted. It has to be noticed. It has to go through notice and comment, but that is ultimately coming. Could take a year or 2, but we'll eventually see that. And the last thing the sports order does is use sort of the so-called bully pulpit of the federal government to promote sex-separated sports. So a lot of sports are controlled by private athletic associations, the Olympics, by the Olympic Committee. Federal government doesn't have direct control over those entities, but it does have sort of the persuasive power of the federal government to try and persuade them to change. So one of the things the order says is the White House will convene a meeting of state attorneys general where it will bring in girls who have been impacted by these policies so they can tell their stories and persuade them how this harms women. So we'll see how effective this ends up being, but as many of you know, the NCAA changed its position very promptly after this. So obviously, there is some power here. And then the last order that I'll talk about briefly is attempting to stop surgical and medical transition of minors. Again, the federal government has limited power here because a lot of this is done by insurance companies and medical providers, and there would have to be a change in law to really effectuate this nationwide. But this order attempts to pull every lever that the government has access, that the president has access to stop this. So the first thing it does is it says in any document that we produce as the federal government, we're no longer going to rely on WPATH. This is one of the things I'm most excited about, but you need to know a little bit about what this is. So WPATH is the World Professional Association of Transgender Health. It's this private group that purports to be a neutral arbiter of guidelines and standards for how to deal with gender dysphoria. And for years in litigation over these issues, courts have deferred to this entity as if it's this neutral gold standard on these topics, but it's really not. It's very much become a political actor. It takes one position, and a position that a lot of experts disagree with. And so the government is saying, we are going to stop endorsing this. And that I think will have a huge impact on how courts view this organization in the future. The second thing is it directs a review of the science within 90 days on how best to treat gender dysphoria within kids. There was a very influential review recently done by England, Department of Health in England, called the Cass Review. And so this is sort of a similar follow-up to that, to have the federal US government do a review of the science and see if this trend to transition children quickly is really beneficial to them or not. The third thing it does, and I think this is probably the strongest assertion of executive power in any of these four orders, it directs all agencies that provide any funding to medical institutions, so this includes research grants, education grants, to take steps to make them stop doing this. So this is very different than the federal government simply saying, we're not going to spend our money on this. That's one thing. This is the federal government saying, if you receive any federal money at all, you can't spend any of your money on this. Now, again, there's not a lot of details in here. So each agency is going to have to figure out if it can do this and how it can do this. And this is currently being litigated. It's been challenged in two cases. Both cases, courts have issued injunctions. I think those are premature because this doesn't actually go through any details here. And I think the Trump administration, the various agencies will then go through and come up with more detailed plans. They will try to make them as consistent with the law as they can, and it just remains to be seen whether that will survive or not. But this is one to keep an eye on. The fourth thing this does is it ensures that government provided or contracted for insurance doesn't pay for this. So in particular, TRICARE, which is provided to military personnel, and then any federal employees are covered by private insurance that's contracted through the government, and the government provides a list of what has to be covered as private insurers bid for those contracts. And so the document saying what has to be covered now says exclude this. And then I'm not going to talk about these two, but very much, but there's a law that prevents female genital mutilation, and the Trump administration has directed DOJ to take as broad of enforcement posture of that law as it can. It's unclear at this stage. It's not a very clearly drafted statute, so it's not clear if it can be applied to surgical procedures, but that's something DOJ will be reviewing and thinking about. And then lastly, it directs the DOJ to help draft legislation to create a private right of action for children who've undergone a procedure with a long statute of limitations. So again, we'll have to just wait and see what that legislation says. but that's the last thing that this order does. So I wish we had time for more. This has been a very high-level overview. I think this is a really strong start to combating this, but there's a lot to come and a lot of details that still have to be worked out. And we'll just see where the administration goes from here. So I'll turn it over to Dan at this point.
Good afternoon now. Thanks, Eric, for joining us. I'm Dan Lennington, Deputy Counsel at Will and Managing Vice President. Since 2021, I've been leading our Equality Under the Law project, which has filed 12 lawsuits against the Biden administration. We were successful in 7 of those and have 5 pending, still with the Trump administration. We've represented clients from 26 states now, over 80 clients, and have been really a nationwide leader in equality litigation. We received all sorts of judgments against the Biden administration for their race discrimination against farmers and small business owners and restaurant owners. And we're very proud of that work. And now there's quite a lot of cleanup to be doing now that the Trump administration is in charge. And so I'm going to talk about these executive orders that deal with race, including diversity, equity, and inclusion, or DEI. So just for some background, when I refer to DEI, I'm referring to this catch-all term, which refers to a policy of discrimination against individuals based on their group identity in order to make up for past discrimination. So it basically treats people as a member of their racial group, and it gives them certain preferences or priorities based on the perception of the policymaker, whether that racial group as a whole needs special help based on the history of discrimination in America. This DEI never accounts for any individuality or any individual circumstances among particular applicants or benefit recipients or businesses or anybody who receives assistance from the government or private enterprise. So it's really a pervasive discriminatory policy, and the Trump administration has issued 4 executive orders that really go to the heart of DEI in America. So before we get into the substance of the orders, I wanted to point out our roadmap to equality. This is another project we're very proud of. We issued this before inauguration, and it was reported by Fox News and the Washington Post that members of the DOJ team had reviewed this. This document, this roadmap, it identifies places in the federal government that use DEI programs, policies, regulations, and it suggests that these ought to be targeted, terminated, and turned off. And so we're very proud of that work. To date, we estimate that 21% of our proposals have been fully adopted and embraced by the federal government. So that leaves a lot of work to be done, but it's only been a few weeks now. So there is more time to get all these DEI policies and programs rooted out of our federal government. Just to provide some examples of what we laid out in our report, we identified about 79 different policies, regulations, or programs that the Trump administration ought to target that are related to DEI. For example, the USDA offers farm loans to Black farmers on better terms than they do to white farmers. The Department of Energy gives out more rebates to you as a homeowner for energy upgrades, depending on whether you live in a minority neighborhood or a white neighborhood. The Department of Treasury gives out small business grants with a preference to minority-owned businesses. NASA, Amtrak, Department of Transportation, they all use racial preferences when they build roads, bridges, trains, and space rockets, assuming NASA still does that sort of thing. So where there's a lot of room for improvement here and work to be done on making our laws colorblind, we are very happy with what's going on so far. So with that, let's go to the next slide. We'll talk about the first one. So the very first thing that President Trump did is he signed something called the initial rescission of harmful executive orders. He revoked President Biden's equity agenda with this first stroke of the pen. On day one of the Biden administration, President Biden said he was going to implement what's called a whole of government equity agenda, which was to direct all federal agencies towards treating individuals not as individuals, but as members of racial groups to make up for past wrongs and what he would call systemic racism. This required agencies to set up equity action plans, which, by the way, we do at the state of Wisconsin too under Tony Evers, and DEI offices, which again we do in the state of Wisconsin. Although the Biden EOs were primarily inward-facing, affecting federal employees, federal training, hiring practices, it also had the effect of tainting all of the Biden administration's policymaking work so that all the people who worked in the Biden administration, whenever they took any action, passing any regulations, making any policies or programs, they had to all do it from a lens of systemic racism so that in effect, certain racial groups should be preferred over others based on the effect of the program or policy, whatever they were doing. So that's why we got to our roadmap for equality, which lists all these harmful things that have been done in the last 4 years. So let's move on to the next one. Right after he signed the rescission of the equity agenda, President Trump signed the Ending Radical and Wasteful Government DEI Programs and Preferencing. This executive order focuses on the programs and agencies and regulations, many of which we identified in our roadmap to equality. This starts off with a very important thing, which, as Lucas noted, is that these executive orders are supposed to set the policy of the United States of America, which is very important for the executive branch to do. And President Trump said, "It is the policy of the United States that Americans deserve a government committed to serving every person with equal dignity and respect." That is a statement that President Biden would not adopt and the Biden administration would not adopt. And so now we have a president willing to say that every single person should be treated with equal dignity and respect, which is an amazing thing that we can say that now and we couldn't say it for the last 4 years. The previous administration's federal policy was to promote the divisive theory of systemic racism and racial equity, focusing on group membership, not individuality. So as far as the substance of this order, this is the order that requires the Office of Management and Budget, all the agencies, and the Attorney General to coordinate the termination of all discriminatory programs. They're supposed to identify and terminate any federal program, including any policy or regulation, program that pays out money, preference, whatever you call it. They say under whatever name it appears, any DEI discriminatory program, it must be deleted and shut down. Also under this order, it directs the agencies to change their litigation positions with regard to discriminatory programs. So this is very good for us at Will. 2 of the lawsuits that we have pending, one is about racial preferences in federal contracting, and one is about federal preferences in higher education. Both of those lawsuits, we're going to be soon engaged with the federal government on settling them because they're going to be changing their position. They're going to be changing their position on higher education discrimination and on federal contracting discrimination. So those are 2 very good things that are coming out of this order. It affects us here at Will directly. It's particularly important to note that in this executive order, President Trump cites a federal statute, which is called 28 U.S.C. 530D. And 530D is a statute passed by Congress that says that the Attorney General is allowed to notify Congress about when it's not going to enforce a law because the Attorney General or the President believes that law is unconstitutional. And so I think a lot of the litigation that's going to go forward with regard to what is the Trump administration doing with regards to certain laws whether they're enforcing them, whether they're not enforcing them, whether they're not spending money, is going to revolve around the executive's authority not to do things, which is a pretty amazing thing in the sweep of history that we're finally talking about an executive who doesn't want to abuse its power and use too much power, but an executive branch that wants to use less power. And so under this Ending Radical and Wasteful Government DEI programs executive order, the president is directing the attorney general to decide whether laws should just not be enforced, whether money should just not be spent. And that is going to be, I think, the type of case that goes up to Supreme Court, a group of cases that go up to Supreme Court. So we're going to get some clarity once and for all in the next 4 years about whether the president can just decide not to enforce laws or not spend money. Let's go to the next slide. So the next day, that was day one. Day two, January 21st, is definitely the most radical and far-reaching executive order that I could have ever imagined the president would sign. I've been in this area for 4 years now, battling against the Biden administration. We've spent the last 60 days thinking and brainstorming about things that the president could do to end DEI once and for all. And this was not on my list of things. It is exceedingly broad and very, very aggressive. It will certainly end up in the courts, but it is, if you wanted to have a president who is going to be serious and aggressive about combating DEI, you got one here with this ending illegal discrimination and restoring merit-based opportunity. So again, the president sets the policy. He says it's the policy of the United States to protect the civil rights of all Americans and to promote individual initiative, excellence, and hard work. Again, amazing that we have to have a president say that, but now he is saying that his policy to protect the civil rights of all Americans. So there's really three things that this January 21st executive order does. First is with regard to federal contracting. So you say federal contracting, most people may roll their eyes over, but federal contracting and government contracting in general accounts for approximately 10 to 15% of the entire GDP of America every single year. So $1 in $10 ever spent in the American economy every single year is a dollar that goes through a federal or state contracting program. So under this, number one, the executive order, it ends affirmative action. Affirmative action was the process that whereby when the federal government issues contracts, race enters the equation and money is to be given out to small businesses and medium-sized businesses and even prime contractors based on the race of their owners. So for example, the Francis Scott Key Bridge in Maryland, the one that was hit by that large ship several months ago, that is being rebuilt by the federal government to the tune of $2 billion. Well, under affirmative action, the federal government has said that 31% of all the money that they spend on rebuilding that bridge must go to minority-owned businesses. That's what affirmative action is, and that has been going on in some ways since 1965, but most definitely since 1980, most vigorously since the 80s. Setting aside money that is going to be spent by our government to do roads, bridges, any sort of building projects, saying that a certain percentage of that, sometimes 10%, sometimes 30%, needs to be spent on minority-owned firms. Under this executive order, that's gone. All federal contractors must stop discriminating based on race, including the hiring of subcontractors. This is effectively an end to affirmative action completely at the federal level, and that is a historic thing. Now, as a side note, President Reagan tried to do this back in the 80s, but Congress threatened him and said that if he undid affirmative action, they would reverse him. And he didn't believe he even had the votes in Congress to undo affirmative action back in the 80s. So President Trump is doing something that's been on the wish list for conservatives for many, many years. Number two, that has to do with people who receive federal money. So this includes all companies, institutions, universities, businesses, hospitals, state governments, local governments, police stations, anybody who receives federal money through either a grant or a contract. And so my calculation is that this accounts for about $1.7 trillion in spending every year. Almost all the money that goes away from the federal government to states, universities, businesses, the health system, all goes out in the form of grants or contracts. This provision says that if you're receiving any money, you must certify in writing that you are not doing any DEI, that you're not having any DEI policies or programs, and that if you're found to be not telling the truth, you'll be liable under the False Claims Act. The False Claims Act is a federal law that provides private individuals and government officials may sue you for triple damages. So for example, let's say the University of Wisconsin receives $1 million grant to conduct research. They would have to sign in their grant agreement a promise not to do DEI. If it was later discovered that UW was discriminating based on race in the hiring of lab assistants or subcontractors, they could be held liable for up to 3 times damages, so triple damages, so $3 million. So that is a tremendously aggressive use of the False Claims Act. I used to litigate False Claims Act cases, and if you are on the defendant side of those, they are very scary and very serious, and they can spell financial disaster for your company or your institution or your government agency that you're a part of. So that's with regard to grant recipients, contracting, and everybody who's receiving federal money. The third thing that this does is it directs all the agencies in the federal government to identify DEI cases that should be investigated and consider whether lawsuits should be brought. So if you're a federal agency and you've got jurisdiction over what's going on in the American economy somewhere, so for example, you regulate banks, and you find that the Bank of America runs a special program where it gives preferences to minorities. Or if you regulate, financial institutions, and you find out that a financial institution is training their employees with DEI and discriminating in hiring and firing promotions. You as the agency are ordered to investigate those allegations, to bring litigation, and decide what you're going to do with those institutions, which in many cases is going to involve the termination of federal funds or the threat of termination of federal funds. So we will have filed several complaints that the federal government is investigating against hospitals, universities, local school districts. And so those could be taken up by the federal government and investigated, and federal funds could be turned off. Let's go to the next slide. And so I'll just talk a little bit, this is my last slide, talk a little bit about what Luke mentioned with the radical indoctrination in K-12 schooling. There is another side to the coin there, which is about DEI, racial ideology that's been taught in schools. Within 90 days, the Secretary of Education's got to identify DEI in curriculum, training, and licensing, see how the federal government supports that. And there's an order that local K-12 districts cannot use their money on DEI. So interesting, as far as whether this is going to be a deterrent against local school districts, I think it's going to be used very aggressively. In Wisconsin, most school districts receive between 10 and 12% or 10 and 15% of their entire budget from the federal government. And so if you're a school district like the Green Bay Area Public School District, which discriminates against kids who need help for being dyslexic, or if you're the Wauwatosa School District, who has decided to close down a school because it's too white, and you're engaging in racial balancing, or if you're a school district like Sun Prairie Area School District, which draws boundaries based on race to achieve a racial balance in their school district, the federal government could investigate you and take away your federal funding if they find that you're discriminating based on race. So that is going to be where a lot of this fight is going to be, is about what exactly can the federal government do to force you to come into compliance with federal law, the law on equal rights, and can they take away your money and rescind what's already been given to you? Can they penalize you? Can they investigate you? And so I'm sure a few school districts, a few universities, a few hospitals, a few Fortune 500 companies in the next 6 months are going to be subject to intense scrutiny and investigation. And we're going to have to let the courts sort out how far the Trump administration can go and what are the limits on the executive power in these EOs. So that's all I have for the race stuff. So I'll turn it back over to Eric.
Great. Yeah, we've got a lot of great questions that have come in, and thank you everyone for sticking with us. I know we've covered a lot of information, a lot of great questions. So I think the first question is for you, Dan. An anonymous attendee would like to know, can they legally say that diversity training needs to be removed from their strategic plan? They've been receiving pressure to get it started, and they would like to remove it.
Yeah, so if you are a private company receiving federal funds in some way, I would say that you should be very cautious about having any DEI in your programs. I would also say that DEI, for the most part, violates Title VII, which is a civil rights law that applies to any employer with more than 10 employees. So DEI, it's been our position at Will that DEI training and DEI hiring promotion procedures at work are race discrimination and are violate Title IX or Title VII. And so it's even worse if you're in the government. So yeah, I would say that if you are deciding whether to implement DEI in where you work, you are facing a significant amount of legal liability if you go forward.
Next question is, can you address how the executive orders could be applied to private schools?
Yeah, I mean, for the most part, the transgender ones, the main way that they would apply to private schools is if a private school is receiving federal funding in some way to do one of the things that the Trump administration has said we're no longer going to fund, that school is probably going to lose the funding for that. So that would, I don't know how many private schools, receive and use federal funds to teach gender ideology, probably not a lot, but to the extent there are some, that would be the main thing. And then the second aspect would be Title IX. So Title IX can apply to private schools if the private school receives federal funds. There is a carve out in Title IX for religious schools. Now, we don't have time to talk about the ins and outs in that, but we've done webinars and on that before that you can find on our website. We've done resources on that before. But to the extent your school is covered by Title IX, you have to know that there is potential legal liability if you're not following the current administration's interpretation of Title IX as it applies to your school. So it's important to pay attention to the Trump administration's directions as to how they interpret Title IX, and it applies to the various topics that we're talking about, athletics, bathrooms, and the like.
What, if any, impact will there be to city and county governments that refuse to eliminate any DEI programs, Dan?
Yeah, it's the loss of federal funds. All cities, counties get money from the federal government, and these executive orders signal that the federal government is going to be very aggressive in investigating cities and counties and local governments that have DEI, and then implementing some sort of an agreement with the city to prevent them from doing it. So what usually happens in these situations with school districts, universities, cities, counties, is that a violation is found, so like race discrimination or something like that, and then the investigators make a finding and say, you need to change your practices. And if you don't, you're going to lose federal funds. And so, as I said, the question is, can the federal government withdraw federal funds from you because you're using the federal funds to do the illegal thing? Or can the federal government just withdraw all your federal funds, no matter what the funds are for, because you're violating law? So that will be an area of litigation. But I think if you are in a city or county and you're a decision maker and you want to limit your liability, getting rid of DEI is the best thing you can do to limit your liability.
And Dan, the same thing would be said for local school districts as well, right?
Yes, and I really think in the next 6 months, it's very likely the administration makes an example out of somebody, and then we're gonna see whether a court upholds it or not. And so what I would say is, for example, like gender ideology, I think it's probably likely the administration just withholds federal funds completely from a district, not whether they're spending it on a particular program or not, whether that's even covered or allowed, just to see if it actually works. Now, it may not work, and a court may say you've gone too far, but I think this administration, if anything, they've shown that they're going to be incredibly aggressive.
Great. Next question. If federal government funds Medicare, Medicaid, how come the transgender executive orders can't extend to hospitals that way?
I think they potentially can. And there's a lot more that I didn't cover in the executive order related to ending the funding of gender transition procedures for minors. There's a whole lot of detailed instructions to HHS to use various levers to end this. But again, we have to see the details yet of how exactly that gets worked out. And a lot of these executive orders are at a high level instructions and don't have those details yet. So remains to be seen how exactly this will all play out.
Yeah, I would just say, with regard to on the race issue, Title VI is a statute that says that if you receive federal funds, you have to promise not to discriminate based on race. So if you're a hospital, for example, and have a nursing program that gives scholarships only to Black nurses, which there are hospitals that do that you are violating Title VI when you're doing that because you're a federal funds recipient. Now, again, the enforcement is another question. What is the federal government actually going to do? Are they going to shut down hospitals? I don't think they're going to shut down hospitals, but perhaps the threat of withholding partially some federal funds from a hospital will force them to comply. And that's a sort of big stick of the federal government that we're going to see pretty soon.
Two things I want to
Luke.
say quickly about the questions. I've noticed a number of questions by school board members about school board policies. So I just want to give a quick shout out to our Restoring American Education project. Our colleague Corey Brewer has done a lot of work to draft model policies to provide an alternative for school board members. So you can find that on our website at willlaw.org/restoringed. One of the questions was, do we have updated policies based on the Trump administration's executive orders? We're always working on updating our policies. Corey is very busy and she takes inquiries from school board members as to what they need and what they're looking for. So they're constantly being updated. But I would say look on our website, and if there's a specific one that you have questions about, please reach out to us. The other generic thing I want to say is there's a number of questions about specific situations. We have a form on our website to contact a lawyer. So if you have an issue that we can't cover in this webinar, please reach out to us, fill out the form. We all three of us and all the rest of the lawyers here get it. We review everyone that comes in. So please fill that out.
Thanks for that, Luke. And given that we're running over time a little bit, I think we've got a lot of great questions coming in, and I just want to let everybody know that it's on. If we don't get your question, you can feel free to email any one of us. Our email addresses are on the website. And so you can feel free to reach out to us if you can't get a hold of we didn't get to your question today. You could also email me, Eric, ERIC, at law.org, and I can forward your question to the appropriate policy expert and legal expert on the issues we were discussing today. With that, I think there's one really good question here for everyone, and it came in, and it was, we hear a lot about blue states, red states, and there's the discussion of some states saying they're going to openly defy the, Trump executive orders on a myriad of things. And some of the questions that we've coming in also are, what is a way to push back on, in some cases, we're talking about folks in very liberal states that want to basically make an issue out of violating the executive orders and the related policies. What is the potential pushback that will come to that? And then what is the best advice for parents and advocates?
Well, that's a pretty generic high-level question, so it's hard to answer because it depends on the details, right? There will be times when blue states and blue school districts resist the Trump administration's actions in a way that violate the law. And if that's what's happening, parents should reach out to a lawyer who can review it. And there might be room for litigation there. There will be times when school districts and states resist and it gets to litigation, and then the courts will have to decide who's right on the interpretation of the law. So it just really depends on the particular issue that we're talking about. But parents need to be actively involved in their school district still, paying attention to what their school board is doing, what their policies are. There is a lot of power vested in school boards and local superintendents, and there's only so much that the federal government can do. So don't sort of rest back assuming that these executive orders are going to resolve all the issues. They're not. So continue to pay attention. And if you have particular issues, please reach out to us. We're happy to be a resource and talk with anybody in more detail about any particular issue.
And I'd say one other thing we can do is that we can file complaints with the federal government on your behalf. And we have done that a number of times. And the complaint procedure with the Department of Justice or the Office of Civil Rights at the Department of Education gives the example that these Trump appointees need to perhaps enforce the law in the way they want to enforce the law. So if they don't hear about it, they won't be able to do anything about it. So, as far as resistance, I say, if a blue state or a city is going to resist, they're going to do so at their own peril. And they're going to find out whether the resistance paid off or not. So it's a very big gamble because at a minimum, there will be an investigation, and having federal investigations of city halls, state governments, universities, in and of itself is a painful process, and can lead to liability. And then having the federal investigators at the end of the day asking you to sign a consent order or a consent decree with them to resolve the allegations is another process that can be quite painful. So yeah, there will be a lot of resistance, but it's just a question of how much resources does the federal government have to bring to bear on these resisting pockets.
Right. Well, with that, I want to thank everybody for taking time out of their morning and afternoon to join us over the lunch hour as we discuss the Trump executive orders. As always, we are recording today's webinar, so we'll be sending out a copy to everybody who registered. And with that, we want to say thank you, everyone.